Worried the divorce will empty your bank account? In Florida, the process you choose is the price you pay. I'll show you exactly what drives costs and 7 ways to keep them down. I'm Vanessa Vasquez de Lara, the founder of the Vasquez de Lara Law Group, where we make lives better in and out of family court. I've been a Florida family law attorney for more than 20 years, and our Miami team has guided thousands of families through divorce, uncontested, collaborative, and when needed, contested. I've seen what inflates the bill and what shrinks it without sacrificing your rights. In this video, I'll break down the number one cost driver that almost everyone underestimates, the baseline fees you should expect, the complexity multipliers like kids and property, and a 7-step cost savings plan you can start today. Your primary next step will be our divorce readiness quiz, free and confidential, to spot your cost risks before they turn into bills. Divorce stress is very, very real. Add money stress on top of the divorce stress, and you can feel like it's too much. You're trying to protect your future, maybe your kids, and now you're hearing horror stories about 5 and even 6-digit legal bills. If that's you, watching this is exactly where you need to be. Most people believe 2 things. First, that a good divorce lawyer is automatically unaffordable. And second, that going to court is just what happens. So it becomes, if I want help, I'm gonna pay a fortune. But here's the truth in Florida. Divorce costs range widely from a few $100s in filing and basic paperwork when things are simple to tens of thousands or more when conflict takes over. And that means you have real control. Conflict drives billable hours from your legal team. Billable hours drive fees. Cooperation through uncontested or collaborative paths keeps both your stress and your legal bills in check. So let's start with the biggest lever, the one that decides whether your divorce is measured in months and thousands or years and tens of thousands. Quick note, I'm talking about Florida divorces. This is general education, not legal advice. Your facts matter. If you need guidance on your situation, talk to a Florida family law attorney like one on my team. The number one cost driver, conflict versus cooperation. The biggest lever on cost is simple, conflict. More conflict means more hours means more dollars. In an uncontested case, you decide the terms and the court approves. In collaborative, each of you has a lawyer, you add neutrals as needed, and the whole team agrees not to fight in court. In a contested case, you hand power to a judge and you open the door to the most time-intensive work, going to court. What makes contested so expensive? Motions, discovery, depositions, hearings, trial prep. Each step takes planning, drafting, review, and scheduling. And every new dispute creates more steps. Here's the math most people miss. One unresolved issue, say who keeps the house, can trigger attorney emails, document requests, a motion, a hearing date, and maybe a valuation expert. That's multiple hours for each side over one issue. Now stack 3 or 4 issues, parenting time, support, property, debts. If you stay positional, I must win, you add weeks or months to your case. If you shift to problem solving, you shrink both time and money spent. Want a lower bill? Lower the battlefield. That doesn't mean you give in. It means you pick the right process. If you can reach full agreement, go uncontested. If you agree on the goal but need structure and privacy, go collaborative. If safety is at stake or someone refuses to cooperate, then we'll litigate and we'll do it well. But know what that choice is going to cost. Even outside the courtroom, reactivity is costly. A heated text becomes a long email chain. A social post becomes a motion. Every spike in emotion creates a spike in hours. Calm, clear communication, it's not just kind, it's cost control. So before we talk dollars, remember this rule. Process and posture determine your price tag. Choose the path that protects your goals and your budget. Now, let's ground this in numbers. What are the baseline costs most people see, no matter which path they take? That's next. The price of entry, baseline costs. So no matter which path you choose, there's always a basic price of entry to file a divorce in Florida, even if you completely DIY it. Think of it like a cover charge to get in. When things really start to get expensive is when you start ordering extra stuff from the menu. Some of those baseline items are the court filing fee, which is a few $100s and varies by county. Then you have service of process, where you have your spouse formally served with divorce papers. Next, you have notaries, copies, and e-filing incidentals, which are small administrative expenses. And if you have kids, there's also a parenting course, which Florida requires if your kids are under 18 before the final judgment. Those are the basics. They're predictable and they're a tiny fraction of what people fear. All in, those costs may be less than $1,000. Where the bills start climbing is outside of this list, when disagreement turns into extra steps that the legal team has to take. Now, a quick reality check on doing it yourself versus having some help from a lawyer. If your case is truly uncontested, you may be able to handle the forms yourself, but a short review of your settlement by an attorney before you file it and even before you sign often saves money by preventing mistakes that cause refilings, rejected paperwork, or terms that create fights later. Also, expect a financial affidavit. It's mandatory. That takes a lot more time than money, but it's essential. When you complete it accurately the first time, you avoid the back and forth that burns billable hours later. So baseline costs are finite and manageable. If your budget is tight, focus on agreement first, clean paperwork, and getting that parenting course done early if you have kids. Now that we've covered the baseline cover charge, let's talk about the multipliers: kids, property, and experts, and how to stop those from ballooning your bill. Complexity multipliers. The facts of your life, your kids, your house, your retirement accounts, maybe even a business, are not the problem. The way we handle those facts decides the price tag. First, kids. When you have minor children, Florida requires a parenting plan and a child support worksheet. That adds steps, but it doesn't have to add drama. If both parents stay focused on stability, we can craft a schedule and support numbers on paper, not in a courtroom. Where the costs climb is when parenting turns into a contest. Think investigations, evaluations, or emergency motions. But keep it child-centered and you keep it cost-controlled. Next, property and debts. Homes may need an appraisal. Businesses may need a valuation. Retirement accounts often have to have a quadro, a special court order, so funds can be split correctly. Those are one-time costs and they're manageable. They explode only when you or your attorneys want to fight over every line item. Then there's discovery, the document hunt, requests, subpoenas, depositions. If nothing is organized, this becomes quite the money pit. But when you front load the basics, last 3 years of tax returns, pay stubs, bank and credit card statements, retirement balances, into a clean packet, you can reduce the back and forth that racks up the billable hours. Finally, experts. These could be people like psychologists or forensic accountants. Sometimes you need them, but the secret to savings is what's called a shared neutral. One neutral financial professional, one appraiser you both trust, one child specialist if needed. You can collaborate even if it's not a formal collaborative divorce. You get clarity without paying for a tug of war. Complexity doesn't have to equal conflict. Use neutrals, organize early, and agree on values where you can. Now, let's turn these ideas into action. Your 7-step divorce cost savings plan. Here are 7 concrete moves you can make to keep your divorce efficient, calm, and affordable without giving up protection. Number 1, pick the right path early. If you can reach a full agreement, go uncontested. If you need structure, privacy, and a neutral team, go collaborative. If safety is at risk or someone refuses to cooperate, we'll litigate, but do it with your eyes wide open. Choosing the forum first prevents weeks of wheel spinning. Number 2, front load the agreement. Start by settling the easy issues and pick the hard ones in a later list. Momentum shrinks the battlefield. You'll be surprised how resolving 3 items makes the 4th less heated. Number 3, get organized. One clean packet for your financial affidavit. Put the basics in a single digital folder. Last 3 years' tax returns, pay stubs, bank and credit card statements, retirement balances, mortgage statements, clear file names, PDF only. The more complete your packet is, the fewer attorney emails, follow-ups, and re-requests you pay for. Number 4, use mediation strategically. One well-planned mediation day can replace months of motion practice. Go in with a written agenda, a range for each issue, and 2 or 3 workable options. Ask for a mediator's proposal only if you're stuck. Don't burn hours re-arguing every point. Number 5, pick your battles. Do the math. Before digging in, ask, What's the dollar value of this fight? If the cost to win exceeds the value of the win, reconsider. Save your energy and your fees for things that actually move the needle. Number 6, mind your messages. Assume that every text or email is going to be read in court. Use the 24-hour rule. If you're heated, draft it, but don't send it. Keep messages short, neutral, and schedule focus. Calm communication prevents attorney escalations like emergency motions or long response letters that can cost hundreds and even thousands of dollars. Make ChatGPT your friend. 7, reality check with counsel. Ask for a realistic outcome range and a step-by-step plan. Then use that plan as a guardrail against fantasy positions and sunk cost spirals. Good strategy saves more than good arguing. Now, let's make this real. I'll walk you through 3 Florida divorce paths, from a clean uncontested to collaborative with real issues to a full contested fight, so you can see how choices change the bill. Let me show you how choices change both time and money. A, paper clean, uncontested. You two already agreed on everything. We drafted clean settlement, 2 disclosures, and attend the final hearing. Your spend stays close to the baseline. Think filing, service, and the right attorney review. And your timeline is usually just a few months. You can probably get this done for less than $5,000. B, collaborative with real issues. You agree on the goal but have sticking points, maybe parenting schedules or the house. We build a collaborative team. 2 attorneys, a neutral financial professional, and a facilitator. In 3 to 6 meetings, you solve it privately, keep control, and avoid court delays. It costs more than uncontested, but typically far less than a courtroom fight. You're probably looking at somewhere under $10,000 in this scenario. And C, a contested fight. Positions harden, motions, discovery, depositions, hearings, maybe even a trial. That means months or years on the calendar and significantly hourly legal spend. Sometimes litigation is necessary in cases with safety concerns or stonewalling, but you know the trade-offs. You're easily going to be spending over $10,000 over the course of the divorce. And it's not at all uncommon for contested divorces to rack up more than $20,000 and up to $50,000 or $100,000. Want A or B? Start with negotiation and the right process. Now, I want to bust 3 myths that turn cheap divorces into expensive ones. Myth number 1, we agree, so we don't need lawyers. The truth? You still need a clean agreement. A short attorney review now prevents costly fixes later. So have a lawyer draft or review your settlement before you file. Myth number 2, we can skip financial disclosure. In Florida, disclosures are mandatory. Skipping them triggers delays and can trigger sanctions. So complete your financial affidavit fully and early. Number 3, the judge will punish their bad behavior with more money for me. That's not how it works. The courts decide on facts and the law, not revenge. Chasing punishment for your spouse often inflates fees without changing outcomes. So aim for fair, data-driven settlement terms, not courtroom point scoring. If you're in Florida and want a personal cost control plan for your case, take our divorce readiness quiz. It's free, confidential, and takes you less than 5 minutes. You'll get a good overview of the things you may still need to think about and get an order. Then you can decide if it's the right time to speak with our team. All you have to do is click the link in the description. And now I have to be very lawyerly. This is just a quiz. Your results are informational. They're not legal advice. And taking the quiz does not create attorney-client relationship. If your situation is urgent, you've been served papers, there's a safety concern, or assets are moving fast, don't wait. Call our Miami office using the number in the description or visit our website to schedule a free case evaluation. Our intake team will gather your facts, and if we're a good fit for what you need, set up a free strategy session. You now know what drives costs. Next, let's talk time. In the very next video, I'll show you how long a Florida divorce really takes, the bottlenecks that slow cases down, and the simple steps that speed things up. Until then, I'm Vanessa Vasquez de Lara, the founder of the Vasquez de Lara Law Group, where we make lives better in and out of family court.